Welcome to our Utility Billing Collection webinar. This is John Carpita at MRSC. With me today are Eric Frimodt at Inslee, Heidi Nagler with the City of Issaquah, and Cheryl Scheuerman, recently retired from the Skyway Water and Sewer District. The webinar will last about 70 minutes. As you can see, the official title is Utility Billing and Collection Issues. This is where we're going today. We're going to do introductions in just a minute. We're going to have a panel presentation by Eric, Heidi, and Cheryl. It's going to be about 40 minutes plus or minus. Then we'll have questions from webinar participants, and then we'll have a wrap-up and talk about available resources at the end of that. Just as a matter of introductions and kind of see what we look like there. I'm John Carpita, Public Works Consultant for MRSC, position I've held for about 17.5 years. And I'm really excited. We have a stellar cast of presenters today. Eric, would you please introduce yourself?
Good morning. My name is Eric Frimodt. I'm a shareholder with Inslee, Doezie, and Ryder in Bellevue, and a member of our firm's municipal practice group. I've been with Inslee for 21 years and primarily represent special purpose districts.
Cheryl, would you like to introduce yourself?
Good morning, everyone. My name is Cheryl Scheuerman, and as John relayed, I'm recently retired as of July 1st from Skyway Water and Sewer District. Skyway is a mid-size water and sewer district in unincorporated King County, the south area of Seattle, southeast Seattle, and I was with the district for 23 years, 6 as office manager and 17 as general manager.
Heidi?
Hi, this is Heidi Nagler, and I'm the Utility Services Program Coordinator with the City of Issaquah. I've been in that position now for 13 years.
Just to give an idea of our agenda for today, we're going to be talking about utility billing issues in one section, utility billing and utility collection issues, of course, and then there's some additional billing and collection issues that are not really, I guess you could say billing and collection issues, but related to the general topic, and we will touch on those. Of course, then we'll have our conclusion and questions at the end of that. So first, we'll be talking about utility billing issues.
Okay, so in beginning this morning, we've identified several utility billing issues that all of us work with daily in our respective districts and cities. Some of the issues are routine and others aren't, but they all work together to help us provide good customer service and meet our fiscal responsibilities and our legal obligations. So today we'll be covering the following: account setup, deposits, landlord-tenant issues, billing adjustments, and overpayment or underpayment of utility bills. The philosopher Plato must have had utility billing foresight when he said, "The beginning is the most important part of the work." And that is truly true when it comes to utility billing. Account setup is truly the most important part of utility service billing. It typically will begin with a phone call or an email or some other way of contact from the customer. Different types of customers: residential, commercial, mixed, and multifamily. And it's really important to remember that information gathered and given at this point sets the foundation for all of the work that follows, whether it's administrative or operational. So you have a captive audience. Your customer needs service, so take time to get as much information as possible or necessary from the customer. their name, their mailing address, multiple phone numbers, email addresses, move-in date, etc. Also, be sure to take time to provide the customer with any billing information or policies that are important for them to know. What's your billing cycle, rate information, miscellaneous charge information, if it's rental property, tenant billing policies and procedures, anything that's really important for you to know about them or for them to know about you. Any extra time taken and effort made in the account setup process will greatly ease future customer service and collection efforts on the account.
Along with account setup, there are deposits. Deposits are a means of assurance that a utility will have money to cover shortfalls at the time of account closure and/or delinquencies that occur in the account. Some cities require deposits from all new customers, while others require them only from customers who may have a shaky credit rating. In either event, there is sometimes a provision that the deposit will be returned after a given amount of months of satisfactory payment history. Having said that, cities will also require imposition of a deposit if chronic delinquencies begin to occur or if the customer's credit rating changes drastically for the worse. Sometimes customers disappear after their accounts are closed, and it is impossible to return their deposit. Eventually, these will become unclaimed property, subject to the provisions of Chapter 61.29 RCW.
For those attendees to the seminar today that are with districts, water sewer districts, I do want to mention that most of my water sewer district clients do not regularly require deposits. And I think this is probably a reflection of the fact that they have an ability to collect delinquent charges through shutoffs or as a result of the super priority lien right. So if you're not collecting a deposit, don't worry about it, but know that it is an option for you.
I agree, Eric. Districts don't usually require deposits because of shutoff and lien rights. In poker, a good flush always beats a full house. And in water and sewer service, a good flush also beats a deposit.
Next, note this list of common landlord-tenant issues. Landlord-tenant issues crop up all the time. Almost all utilities require that the property owner be ultimately responsible for the payment. Some will even require that the property owner be the customer of record, while others will allow the tenant to establish his or her own account. RCW 35.21.217, cities and towns require that the utility notify the landlord if a tenant is delinquent, if requested to do so in writing.
With respect to water and sewer districts, the duplicate billing requirements relating to landlord-tenant issues are found in RCW 57.08.081, subparagraph 7. Based on my experience, most of our water sewer district clients prefer to bill the owners of the property since they are ultimately responsible for the service charges. I also want to note that I've had several situations over the years where a landlord will request the district to terminate water service as a means of forcing a tenant to move out. I think it's important that you understand that RCW 59.18.300 specifically prohibits a landlord from taking this action. In my experience, a landlord oftentimes will not tell the district why he or she is terminating water service. However, if you know or learn that water service is being terminated in order to force a tenant to move out, the district needs to refuse to participate in the landlord's action and immediately restore water service if the water has been shut off. You need to have a conversation with the landlord that if they want to evict a tenant for non-payment or other reasons, that the landlord needs to follow the statutory procedures in the Residential Landlord-Tenant Act, that districts and other agencies need to make sure they are not a part of the landlord's attempts to evict a tenant.
Skyway, Eric, is one of the districts that requires that the legal property owner is billed. The account always stays in the owner's name, but with the owner's permission, a duplicate bill is sent to the tenants. The owner and tenant then have their own private agreement as to who pays what and how they pay. If the account is not paid, service is terminated to the property when the account becomes delinquent. Over the years, the district's had many requests from landlords wanting to terminate service as a means of forcing tenants to move out. Our customer service staff always declines these requests and notes that the district only terminates for account delinquency, not for the purposes of rent delinquency or property management. We tell the customer that politely that the district won't participate in any landlord-tenant disputes, and the customer is referred specifically to the RCW that has been referred to, RCW 59.18.300 and the Landlord-Tenant Act for further information.
Okay, so we're moving on to the billing adjustments due to leaks and meter error or failure slide. And in most cases, the responsibility for maintenance and repair of water service lines on private property rests with the private property owner. Most water utilities are going to have situations where a customer's private water line will leak, resulting in heavy consumption of water and a large bill. Many districts have leak adjustment policies that attempt to relieve the customer from the burden of paying for a large bill. While the policies differ, most include limitations on how often the request for a leak adjustment may be requested. For example, you could have a one-time adjustment or one time in so many years, for example. Further, the policies generally require that the property owner provide evidence that the repairs, and in some cases replacement of the line, were made in a prompt manner. I think it's important that when you're adopting a leak adjustment policy, the utility needs to be careful to include terms that include the property owners to act responsibly to save the precious resource of water. Cheryl or Heidi, do you have examples of what your agencies do in this regard?
Sure, this is Heidi, and with the City of Issaquah, we do have a one-time leak adjustment policy. Once the owner has provided documentation and it has been shown it's a permanent fix, the city will adjust up to 2 billing cycles. We do bill bi-monthly here at the city, and we will adjust back to their last year's average at that time minus city's cost. And Cheryl?
This is Cheryl, and Skyway does have a leak adjustment policy. Like Eric said, there's certain requirements. It needs to be repaired promptly, and there is a form that needs to be filled out. It is submitted to the Board of Commissioners for final approval. There's a one-time adjustment policy, not one time per property, but one time per leak occurrence. And as long as the leak is fixed, it's usually the difference between the wholesale and the retail rate is adjusted off. What happens is there's a 3 to a 5 year average that's calculated for that billing period, and then the difference is adjusted off.
I had mentioned earlier that the responsibility for private service lines generally resides with the private property owner. However, I want to note that it's possible that a district, for example, may have a franchise agreement with a county or city that would require the district to assume responsibility for private water lines that are located in roads or along public rights-of-way. Last couple of years, I've had a couple circumstances where there have been private service lines that end up in locations that are in roads. And King County's franchise, for example, would require a district to undertake the repairs of a leaking service line by contract which in turn then means that the district would have to proceed to try to collect that amount, recover the repairs from the property owner. So that's kind of an exception to the general rule. So be aware that you might have a franchise agreement that might have some bearing on that kind of an issue.
And that's really true, Eric, in unincorporated King County with the franchise. So in response to that, Skyway now requires property owners that do have private lines in the public right-of-way to record a notice or covenant on the property's title to notify all future owners of the location of the service line and the district owner responsibilities for right-of-way repair and cost reimbursement. This requirement was implemented to aim both at meeting King County franchise agreement provisions, but also to avoid property owner surprises if a situation like that comes up.
All right, so let's talk a little bit about the requirement for utilities to adjust billings that result from meter failures or errors. When we're talking about mechanical meters, my experience is most of the time when you've got a bad meter, they're actually under reading. I guess that there could be a circumstance when it may read more than consumption, actual consumption. I'm also aware that a lot of districts now are moving to electronic read meters. To date, I have not had any experience that personally that show that there's been a large incidence of failures with respect to electronic read meters, although because it's technology and computer technology, I'm assuming that that is something that we will experience in the future. But if there are underbillings or overbillings, then the utility needs to look at that and take appropriate action. I also want to mention that one of my clients in the last couple of years was actually taken to a small claims court by a customer who had used an extraordinary amount of water. The district was unable to determine through kind of a visual inspection from public right-of-way that there were any pools of water anywhere. They had a general sense that they likely left a hose on, or maybe the water was left running and it simply went down the drain. But this property owner took the district to small claims court, offered evidence from a plumber that he had looked at her plumbing and didn't find any leaks. Well, if you left water running and it went simply down the drain and into the collection system, you're not going to see a leak. If you happen to get taken to small claims court by a property owner, you always have the right to have your attorney remove that to district court, where you could have attorney representation. But the amounts used are going to be generally small, and you can handle them yourselves in a small claim setting. But I think it would be a good practice to make sure that you have the meter tested, so you can offer evidence that it was in good working order. And it's also important that you help educate the court to make sure that they understand that the district or city or other agency is required to recover all its costs from customers, and there are legal issues associated with not recovering. In this case, the small claims court actually found in favor of the customer, and we simply dropped it rather than taking it any further. But just a heads up. Now we're moving on to overpayment of utility bills. In situations where a utility overcharges the customer, a refund will need to be made. The statute of limitations will likely be 3 years under RCW 4.16.080 subparagraph 3, which is an action based on a contract or liability which is not in writing, or possibly it could be under RCW 4.16.080 subparagraph 4, which is an action based on fraud which accrues when discovered. Now, when you mention fraud, it sounds kind of like a harsh statement, but there is a case, the Western Lumber case cited in the materials, where it was discovered in that case that there was an extra meter on the water line that resulted in the utility actually double charging the property owner for water. The utility in that case initially took the position that it would was willing to refund charges, the overpayments, for a 3-year period, claiming that the rest were uncollectible by a statute of limitations. The lumber mill in that case actually sought to recover the full additional 12-year period. The court ruled that the billings constituted a false representation of the water actually consumed, meaning fraud, and even though that was innocent, and allowed the customer to recover overcharges for the full 12-year period. So keep that situation in mind if you happen to have a similar experience. If the overpayment happens to arise from a written contract, then you're going to fall back into the normal statute of limitations, which would be 6 years that apply to written contracts. You could have a utility service agreement, for example. So I just want to make sure if there's a written contract, you're going to get an extended 6-year statute of limitations. All right, with respect to underpayment of utility bills, utilities are also required to collect underpayments. And in my experience, there is still some debate about whether what the applicable statute of limitations is in a situation of an underpayment by a customer. If the charge arises from a written contract, again, it's going to be a 6-year statute of limitations. Conceivably, I guess you could have a new customer agreement when somebody opens an account that would be in the sense of a written contract that would automatically make the 6-year statute of limitations apply. If you don't have a written contract, then it becomes a little more complicated. It's possible that the unpaid utility charge would constitute an account receivable that's incurred in the ordinary course of the utility's business, in which case the statute of limitations would be 6 years pursuant to RCW 4.16.040 subparagraph 2. However, to my knowledge, there are no cases that have specifically addressed that issue, and I think over the years I've heard some requests for possible clarification of that statute to make sure that it would address that issue. The other alternative is that an underpayment would be subject to a 3-year statute of limitations under RCW 4.16.080 subparagraph 3. And there's a case called the City of Snohomish versus Seattle Snohomish Mill Company, which is an unpublished decision, so we can't really rely upon it and cite it in a court proceeding. But in that case, the court found that a 3-year statute of limitations applied. And I think importantly, the court also applied what's referred to as the discovery rule, which is, when should the customer knew or reasonably have known that there was an underbilling going on, or in this case, actually, when should the agency have known that there was an underbilling going on? Therefore, what we have recommended to our clients when these kind of issues come up, we think that there's a good basis to resolve claims by asking for payment of an undercharge that would cover a 3-year statute of limitations period. And the negotiation could be that, look, we want to resolve it, we're willing to go with a 3-year statute of limitations, but conceivably, if we can't collect it and we have to go to court, then we may end up actually asking for 6 years worth of underpayments. Also want to note the court's ruling in a case called Housing Authority versus Northeast Lake Washington Water and Sewer District that suggests that the failure to collect undercharges would constitute a rate preference or an act of discrimination, and that utilities are obligated to collect the underpayments. I think that's an important concept in the sense that, at least by that footnote, it gives it suggests that that agencies do not have an option not to collect underpayments, and if you don't, that arguably somebody else could say that you're granting rate preferences or engaging in rate discrimination. The other issue that we've probably heard raised before is that failure to collect for service charges could constitute a gift of public funds, and therefore the district needs to make reasonable efforts to collect all charges. I think it's important to, when you find yourself in those kind of situations, to to have a conversation with the customer and let them know that, yeah, there may have been a mistake made, but you know, we apologize for that, but there is a legal obligation for us to collect an underpayment. So just a heads up on that.
As you can see, this slide shows the most effective way of enforcing utility billing collection. I'm not sure how many of you agencies have elephants on your staff, though. We're going to look at some utility collection issues now, moving ahead from the billing part of it. We're talking about penalties and interest, and termination of services, payment arrangements, utility liens, and foreclosure. Everybody's favorite, collection agencies. And boy, bankruptcy has all kinds of issues involved in it. We'll also talk for a minute about property sales.
For number one issue, penalties and interest, utilities can charge a late fee on delinquent utility accounts. For the City of Issaquah, this is an amount that is set by city ordinance. The City of Issaquah does charge a fixed 10% penalty per city ordinance on water, sewer, and storm. Our ordinance further states that an additional 10% will be assessed every 60 days as we are a bi-billing monthly city. We, however, do not charge a late fee in connection with a prior late fee, only on the unpaid services. In addition to penalties, there are fees set by city ordinance that charge to post a notice on delinquent accounts, as well as a turn-off and on-meter fee if that were to occur.
So like Issaquah, Heidi, Skyway Water and Sewer District also charges late penalties on delinquent accounts per statute. A 10% penalty on the current billing's unpaid balance is assessed 10 days after the grace period, which is the bill's due date. Late penalties aren't cumulative. Only the current billing's unpaid portion is assessed the fee. Also, like Issaquah, Skyway charges other fees associated with other account services, such as shutoff, reconnection, etc. But these fees are set only to recoup the actual cost of providing the service, the labor, the gas involved, and all rates, charges, and fees are set by district resolution.
Okay, so we're moving on to the termination of service topic. And there are a few things that I want to mention. With respect to combined accounts, those that include water, sewer, or multiple utilities, garbage, electricity, your codes or your ordinances should establish an order in which the payments would be applied, with the most current water billing as the last priority. You would apply payments to sewer and other utilities first, as it's easier and it's most effective to terminate water service. So make sure that in your codes, your policies, or your resolutions that you set an order of preference. And if you prioritize how you apply a payment, then you can take care of multiple delinquencies. And for example, you would leave the water account outstanding, and you do that because it can be an effective collection technique to terminate water service. And I know utilities don't like to terminate water service, but again, it is an effective collection means. As noted in the slides, though, it is also can be very frustrating and distasteful. So I think my experience is most of my clients, and most utilities for that matter, work very carefully with the customers to avoid the shutoffs. Also want to mention that with respect to districts, the RCW 5708 actually gives districts the right to terminate sewer service. I've only heard of one district in my 21 years that ever attempted to terminate sewer service, and that didn't turn out particularly well. So that is a mechanism that generally isn't used by districts, even though the statute might provide for that. If you're going to terminate service, it's important that notice would be given, and as noted on the slide, in the alternative language if needed. If you know that there's a resident or an owner that does not speak English, it would be advisable to have an alternative language, in their native language notice, so they could understand what the notice said and could take appropriate steps. The notice should say, for example, it should give them notice of when the services will be terminated by a given date and a time. And that's generally to address just the general due process concerns, and that's often described as being a notice and an opportunity to be heard. All right, so the notice should include information with respect to an ability to contest the situation or protest the bill. You should include in the notice the name, address, telephone number of the person that should be contacted, whether that's the accounts manager, or the smaller districts, oftentimes that comes into the office manager or even the district manager. So let me touch a little bit on the issue of door hangers. And I know a lot of districts still use door hangers as kind of the last step in the process. There has been some discussion over the last several years about the expense of using door hangers. If you do that, you obviously are using a district employee or city employee to go out and hang door hangers. So there's certainly an expense associated with that. I would mention that I don't think you have to do a door hanger. Some districts find that to be a good collection practice. I'm also aware of the fact, though, that you have people that are kind of the habitual late payers that use the door hanger as really kind of that final reminder, oh, I better pay my utility bill. So I would suggest that you can look at adopting policies that would attempt to impose the added costs of hanging door hangers if you choose to do that, or whatever other notice you may use. You can do certified mail. You could do regular mailing for that matter. With respect to how much time should be allowed between a notice and termination of service, I would I'm going to kind of revert back to it needs to be a reasonable notice. Well, what's that? I don't know that I have a good answer other than 7-10 days, time. Basically, you need to give time for the customer to come in and to raise issues with respect to the particular charge that they're protesting. Now, if you have multiple notices, multiple attempts to collect unpaid service charges, I don't have any problem with the final notice that would be sent out saying, look, if you don't pay, this is your final notice, we'll terminate water service in a very short time frame. I just want to make sure that you wouldn't come out of the box with a very short, 24-hour, one-day time period. I just think it's much better to work with a customer to get them to pay their bill, and then ultimately, if you can't collect it, then to terminate water service after having worked with them for a while. I'd also mention that many of my district clients will actually work with customers and will accept partial payments. And from my perspective, I think that is an acceptable practice. I think accepting partial payments is an accommodation, certainly, but it also avoids maybe a more expensive collection action. So if a customer comes in and is willing to make a partial payment, I don't have a problem with an agency collecting that. I would recommend that you put that in writing when the next payment would be made, and then hold them to that. And if you feel like there's an abuse of that agreement and it's continuing to get worse or very sporadic, then you might simply, as a policy, decide you're not going to accept anything other than a full payment. Another issue that I want to mention that you should keep in mind is the possibility that there could be a medical condition or medical equipment located within the house that could be affected by a shutoff. If you're aware of that, I know some districts might keep a dialysis list, for example. If you are aware of that, then you certainly would not want to terminate service if it was going to jeopardize the resident's health. So keep that in mind if you do have knowledge that there is a medical condition within the household. A couple of statutory references. I know the water sewer districts can shut off water after 30 days delinquency. That's RCW 5708.081 subparagraph 5, and the city statutes related to shut off is after 4 months of delinquency, and the references that are there in the materials 35.21.290 and 300.
So moving along to payment arrangements. Payment arrangements are made for customers who like to have the option to budget their bill and payments equally over time. Another type of payment arrangement is for customers who are delinquent and need more time to pay, but would like to prevent shutoff, as was talked about earlier, of water service. In line with the Fair Practices Act, the City of Issaquah will work with the customer on their payment plan as long as that time is reasonable. We also have several local agencies here in Issaquah that offer payment assistance, typically once in a 6-month period, to assist these customers in preventing water service from being shut off.
Skyway Water and Sewer does not provide budget billing, but we do work with customers in regards to payment budgeting on their own and making payment arrangements that are aimed at avoiding delinquent shutoff. The district has a customer assistance program that's available to assist qualifying customers that are experiencing temporary financial hardship. And we provide them with a list of local service agencies that may also be able to assist them in the payment of their bill. Everyone who is in the utility industry, shutoff day is truly the worst day of any billing cycle. No one likes to, the guys don't like to shut off water. The office doesn't like to take the calls. It's a pretty miserable day. So anything that can be done to be proactive and make payment arrangements ahead of time is really the way to go. It keeps customers happy, gives customer service, keeps staff happy, and keeps you out of the news, keeps you off of the Get Jesse feature on Channel 5, and it can also keep you out of the papers. There's a recent article in the paper about a woman who has been experiencing financial hardship for quite some time, and she had her water service shut off, and she called a reporter and marched into City Hall with a box of dirty dishes and proceeded to the men's restroom to do her dishes. And you know, we've all been there. You can imagine what kind of news that gets. The interesting side on this is that the customer was trying to get the city to consider payment in community service hours for her bill rather than in in cash. So it just, the shutoff and the whole termination of services poses a lot of different issues to all of us. So payment arrangements are definitely the way to go if at all possible.
All right, so moving on to utility liens and the foreclosure process. I won't spend a lot of time on this, but I do want to say that in addition to termination of service and turning accounts over to collection agencies, for example, all utilities have the right to file a lien or perfect their lien and to foreclose that lien. And by foreclose that lien, by statute, all agencies are going to have a statutory lien that's going to be against the real property. And the foreclosure process is going to be spelled out, how you do that in the statutes that relate to cities or counties or water sewer districts or PUDs. So it's kind of like a cookbook of procedures or steps you would have to take to foreclose against real property. But importantly, the foreclosure, if you actually get that far, you're getting a judgment for the unpaid delinquency. Most of the utility statutes that I've looked at have provisions that allow for the recovery of foreclosure costs, attorney's fees, title reports. So you could have a very small amount, for example, and end up that amount would increase significantly if you go through a foreclosure. And if you go through a foreclosure, the sheriff would eventually sell the real property, and you would use the funds basically to pay for the unpaid utility and the costs incurred. In my 21 years of experience, I have only personally been involved in one lien foreclosure that got to the foreclosure point. So I think it's extremely rare. Filing liens is not rare, and that usually is enough to secure a payment either through the property owner. Sometimes lenders cure the defaults in order to protect their liens if they have a mortgage on the property. So keep that in mind.
Moving on to collection agencies. Collection agencies can be used to recover delinquent charges when you yourself cannot. Alliance 1 is the agency used by the City of Issaquah. Per contract, we do not add any fees to our delinquent amount submitted to the agency. The agency will collect 100% of our principal amount, and then they themselves will add on a collection fee, which in our case is 35%.
I want to mention that for those agencies that use private attorneys or contract attorneys, not in-house counsel, to collect delinquent accounts as it relates to residential or consumer accounts, it's important that the attorneys who are handling those kind of matters be aware of the Fair Debt Collection Practices Act, as contract attorneys would be considered debt collectors under that act and must comply with the statutory requirements. The letters, for example, would have to say that this is an attempt to collect a debt. Information that you give will be used in the collection of that debt. There's some statutory language that needs to be included in there. So there can be some strict penalties that would apply to an attorney who is attempting to collect a debt on behalf of a utility. So I just want to put that on the radar for your private attorneys that might be doing collection work for you.
And here in our next slide is an example of a notice of intention to send an account to collections that we did run by our attorney's office, and we used this one to notify customers that they could be referred to collections if they were not to pay.
All right, so turning to the issues that occur in bankruptcy, I think over the last 4 or 5 years, my municipal clients have experienced a large increase in bankruptcy filings, as well as foreclosures, in some case receivership. So I want to just go through some things that you need to be aware of with respect to bankruptcies. The date that a bankruptcy petition is very important because it is the date that establishes what's called the automatic stay on the attempt to collect a debt. Utility cannot collect a bill or enforce liens for delinquent charges that occur before that date. So if you get notice from a bankruptcy court of a bankruptcy filing, you need to look at the date that bankruptcy was started, and then you consider what you go pre-petition debt, all debt that was incurred prior to the filing, and then the other concept we'll talk about is post-petition debt. One of the recommendations that we have for our clients is that a utility should create a new billing account for the customer to clearly separate the pre-filing utility charges versus the post-filing utility charges, and that you can simply do that by most of your computer systems would allow you to assign a new account that would still be attached to the service address, but will allow you to segregate and to track out those post-petition debts. Another point that if the service was terminated for non-payment before the filing date, the utility must restore service of the water. You can't continue to use that as a mechanism to collect against them. I think that there have been some cases that have viewed that as an attempt to collect a debt. So the automatic stay basically says don't do anything to attempt to collect the debt as it relates to the debtor that filed. So moving on now to the next statute that relates to methods of how you collect your pre-petition debt. Well, you would want to file your lien notice in the bankruptcy court. You should not call or write the debtor. You can send notices to the debtor's attorney if they have one, or to the bankruptcy trustee. You can file a claim, and I give you the address of the U.S. court there that you can get a bankruptcy form, and you can use the forms to complete your claim that then gets filed in the particular bankruptcy matter. It's important that you would show the agency's claim as a secured claim. And when I say that, again, I'm assuming that you're operating under a statute that gives you a lien, statutory lien against the property. And because of that, we take the position that that is a secured claim. And by checking the secured claim box on the claim form, it actually gives you some priority over general unsecured claims. I should say that it's not uncommon to see some filings that will list delinquent utility charges as unsecured debt, and you need to make sure that you clarify and correct that misnomer there, because it in most cases will be a secured claim. You would attach backup materials to the claim form. You can do an account statement that would show the current amount that was due as of the bankruptcy filing. Just attach that to the form and file that with the court. You can also send the trustee a letter indicating that the utility has an intent to foreclose its lien if necessary, and again, the lien is against the real properties, and you're not attempting to collect that necessarily against the debtor, the individual, and your communications again should go to the trustee in that case. I would also say that when you're dealing with bankruptcy matters, you know, you can file claims pretty easily. I think most people can do that. I would suggest that you consult with your legal counsel. I don't practice regularly in the bankruptcy context, and the large bankruptcy code provisions make me a little nervous at times. So I like to consult internally at my office with people that practice bankruptcy all the time to make sure that I'm not doing something erroneous. So I would refer you to your local counsel or in-house counsel to make sure that you're doing things correctly to get your claim noted. And then once you file that claim with respect to the pre-petition debt, it simply is going to go through the bankruptcy process, and in most cases that you know, it could get paid. In some cases, the debtor may be discharged from the payment, but the lien, our bankruptcy attorneys take the position that that lien is going to remain against the real property. So you might be able to collect that later. So we've moved on to the next slide, which is collecting post-petition debt. So I had mentioned earlier that you would close a pre-petition utility account, or at least open a new utility account to track the post-petition debt. You probably would be a good idea to track the developments in the case. You can open a PACER account, which is just the computer system used by federal courts. It allows you to put in the case number and kind of track what's going on in the case. See whether there are any developments that might relate to you know, whether you're going to get paid or whether there's a zero chance you're going to get paid. You can kind of see what's going on in the court. Another important factor in bankruptcy is to demand assurance of payment deposit. Basically, in the bankruptcy code, there is a specific provision, 11 USC section 366, that gives utilities some tools to use, basically, to collect the debt. It would, or actually, let's say collect the debt, with tools against actually going further in debt with respect to post-petition obligations. So that first reference to section 366 subparagraph A is just kind of a warning to utilities that you can't alter, refuse, or discontinue service to somebody who's filed for bankruptcy. So make sure that you don't do that. That would be viewed as a violation of the Federal Bankruptcy Code. But you can ask for adequate assurances of payment in the form of a deposit. And so that subparagraph B, section 366B, talks about the utility may alter, refuse, or discontinue service if the debtor, the trustee or the debtor refuses to provide adequate assurances of payment. So if you make a request that, look, we would like a deposit to make sure that we're going to get paid for our post-petition debt, if they don't pay that, in that case you would have an ability to terminate service. Again, I would want you to contact or work through your attorney in that matter, make sure that you don't run afoul of something. But that can be an effective tool I want to alert you to. So moving on then to a little more detail about the assurance of payment, to slide 28. So the assurance of payment basically can be in various forms. It can be a cash deposit, it could be a letter of credit, it could be a certificate of deposit, a surety bond. So my experience is most of the times you're looking at a cash deposit. I'm going to move on then to the next slide that will give us a little more information about the assurance of payment issues. When you're making a request for assurance of payment deposit, you should send it to the debtor's attorney or to the debtor if there is no attorney involved. You can ask for, we recommend 2 or 3 months worth of average bills, and again you'd calculate that amount. You would request an adequate assurance deposit that you would keep in a separated account that would allow you to make charges against that account if the debtor did not pay post-petition utility bills. And if they either don't make the deposit, or if they don't make the deposit, you have the ability to send a shut-off notice. If they do make the deposit, you can draw off of that account for unpaid post-petition obligations. And if you deplete the adequate assurance deposit, you can certainly request a new deposit be made, and if that's not made, you can terminate service at that point. It's just important not to make the deposit request too large because it could be challenged by the attorney for the debtor. And we generally recommend 2 to 3 months of average bills. So that's all I have really with respect to the bankruptcy issues.
So moving on to property sales. Property sales can be submitted by a buyer, a seller, and/or escrow. The escrow agent may submit a closing bill request in writing via either the mail or fax. If the estimate or final bill is requested, the response is to be 3 days via fax and 7 days via mail. Keeping the confirmation fax of the estimate and/or final bill is a great way to track these time requirements for the RCW 60.80.020 Section C.
We're going to move on now to some additional billing collection issues, which are really billing collection, but they are things that utilities deal with on a regular basis. The first is the identity fresh red flag rules and senior and low-income utility rate discounts. We also have something called snowbird or voluntary discontinuance of utility services.
All right, so I want to just briefly mention the identity theft and red flag rules. These are not new. These were adopted by federal statute in 2003, so I'm assuming that most agencies have already dealt with these, the red flag rules. Basically, it was legislation that was intended to develop systems within utilities, well, actually covered accounts, so banks and other accounts that were covered under the federal statute. It just so happens that the definition of covered account, we believe, covered utility accounts, and so that's why we're talking about it. But the intent was for primarily businesses or utilities that are taking information with respect to credit card numbers or other sensitive information, that they have a program that would protect the information of a customer. And so if the red flag rules are not something that sound familiar to you, you might check and see whether your agency has actually adopted a policy about that. And I believe MRSC has some good materials on their website that would provide good samples of policies that you could adopt. And again, it's just if you get a call, for example, from somebody that is asking for information that you think is suspicious or wanting to change the name of a utility into somebody else's name, how do you respond to that? Utility accounts actually are a common mechanism for somebody to try to use that as support for establishing a new identity. And they say, well, this is my address, but sometimes they can just simply call up an agency and get through fraud, get information that might help them establish a new identity. So just be aware of that.
There is specific statutory authority that allows utilities to offer reduced utility rates for low-income senior citizens and other low-income customers. And that is RCW 743807. The statute allows for flexibility in establishing eligible income levels for these reduced rates. Some agencies use a percentage of the HUD guidelines or other guidelines that set poverty levels on a national level. Other agencies use the same income levels and forms that allow property owners to qualify for property tax exemptions under the state statutes.
Skyway is one of the districts that has established discounted water and sewer rates for qualifying low-income senior and disabled customers. The discounted rate is established by resolution, and in accordance with RCW 57.08.014, the district annually publishes the impact of those rate discounts or subsidies to all the customers, so that all customers know that the discount has a rate impact on everyone. But it's important to do.
Moving on to voluntary discontinuance of utility service, or we like to call them snowbirds. The city of Issaquah no longer offers voluntary discontinuance of service. King County Metro requires payment for the sewer connection. So if someone were to suspend their service as a way of saving costs well away, the other ratepayers would have to pick up this cost. So there are basic charges for sewer and water that must be paid. If a customer needs to discontinue service for an extended period, they can ask to have service blocked at the meter, thereby making sure that they do not incur charges that vary with the demand for water.
So Skyway continues to offer a vacancy rate billing for qualifying customers and accounts. A fee is charged for the service, which covers the cost of the account setup and the meter lock off. Because the meter is locked off and there's no water consumption, the vacancy rate avoids the sewer charge, but there is a minimum monthly base rate or a meter access fee that continues. And there's a form that the customer completes that confirms that they will be vacant and what type of utility they are, whether it's water only, sewer only, or both water and sewer.
Okay, we're moving on to conclusions and questions now. We do have a number of questions, so while some of you are going ahead and typing yours in, we'll go ahead and start with the ones we already have here. And this, I'm going to throw this out to the all of our panelists. Do you adjust, this is regarding leaks, just sewer, or do you give adjustments for the water?
You know, in my experience, most of the leak situations seem to come up in the water context. And I guess some of that would depend upon how you bill for sewer. So if you had a sewer charge that increased, for example, because of, was not a flat rate, but increased because of, you know, some error, then I think you would probably want to consider adjusting that as well. But it might be agency specific to what their code or policy is.
Yes,
I think
with respect to the city of Issaquah, if the water went down, the leak itself down the sewer line, we would not adjust sewer. But if it did impact, the sewer cost and it did not go down the sewer, then we require documentation to that fact, and we would adjust it, because with King County Metro, they are going to be looking for what adjustments you did and why, and if they did not qualify, then they will ask for those funds back.
And Skyway does not adjust single-family sewer because it is a flat rate with King County, but it does adjust commercial and multifamily because it's based on water consumption, and if it's a leak, it didn't go down the sewer.
Any other thoughts on that? Okay. Then the question is a city or a district required to send a copy of a bill to a tenant of a rental property? And the comment is, we bill only the property owner and do not courtesy copy the renter. We will send a door hanger if service is up for termination due to non-payment. Any comments on that?
I guess I'd refer to the attorney on that, but the property owner is the owner of records. So from Skyway's perspective, the tenant billing is a courtesy. It's a customer service to make it easy for the tenant and the property owner to communicate, but not a requirement.
Yeah, I would agree with that, and I happen to have the statute relating to water sewer districts in front of me, and that statutory language, the only requirement relates to if you are billing a tenant and the owner requests a duplicate bill, you've got to comply with that. It's not the other way around. So if you are billing the property owner, I don't believe you would be required to also bill the tenant, except if you were going to do it as a courtesy.
Heidi, do you have any comments on that?
With the city of Issaquah, we do have a form called a Statement of Responsibility for transferring the responsibility from owner to tenant. Once we do that, then the tenant is the one that receives the bill. Just like Skyway, they can request a copy, and we would send that out. When it gets to shut-off mode, where we're actually posting a notice on the home, we would actually post it to the tenant, and we would mail a copy to the owner. That way, they each have the equal amount of time to resolve the account before the city would actually shut it off.
We have a question that relates to cities. The statutes that were referenced, the 39, 21, 290, whatever it was back in that one slide, says cities can, after 4 months, shut off water, and that's to enforce a delinquency of up to 4 months. And the question is, can a city shut it off after 30 days? And I think from the city's perspective, I think the answer is no, but I'll defer it to anyone else here.
I don't know the statute that would relate to cities specifically. That's something that maybe I can confirm, and we can get an answer specifically to that one. So I know with respect to districts that it's a 30-day period. So would need to look at that.
I think just some of the questions I've answered that in the past. This is John Carpita, MRSC. Questions that I've answered on that, basically, you can only enforce a shut-off after 4 months delinquency. So I would guess probably the answer is no, you can't use a 30-day shut-off for cities. We have a question about medical conditions. How long do we have to use utilities on for a situation where they have a medical device without payment? And then the question also is, what documentation do we require from the customer?
I think it's a difficult situation if that were to occur. I don't think a utility is obligated to give free service, even to somebody that has a medical condition that may be dependent upon water. So the main recommendation we have is just to be aware of the fact that if you have somebody in a house that possibly could be subject to a termination of utility service, that you know that, and you might not do that as soon in that circumstance as you would others. And I think you could still work with that owner, for example, to come up with payment arrangements that were reasonable, and if they didn't make a payment within a reasonable time, then you could move forward with a termination of service. If it's a district client, I'm less concerned about that, just because, well, most agencies are going to have a lien, and so you're going to still have that super priority lien that's going to give you some time to work on this. You may find yourself in a situation, I guess, where somebody just said, "I'm not paying, and I'm going to live out my days here and not move and continue to incur charges." I think you could, at some point it becomes unreasonable. If you were really concerned about liability, you could go get a court order authorizing you to terminate service. But it's just a difficult one to answer with real specific information.
This is Cheryl, and I do have a little bit of information on that. I can't respond to all medical issues, but I do know that with regard to dialysis, most of the notification to the district will come through Northwest Kidney Foundation or through the kidney center that the dialysis is happening at, or if it's home dialysis, same thing, it's being coordinated through kidney dialysis. And if there is a situation where the patient, the water is at risk of being shut off, the Northwest Kidney Foundation has a fund specifically designated to help with utility billing. And at Skyway, we have contacted the kidney center in that situation, and they have sent a voucher for payment of the utility bill. So that's one resource available.
Okay, moving on to another question here. Can you both lien a property and turn it over to the collection agency at the same time?
The answer to that is yes, and in most cases, for example, for water sewer districts, the liening process sometimes just certifying to the auditor that there is a delinquency, but there's no reason why you can't do both. And in some cases, I think it's always good for a utility to perfect their lien right as it's required under the statute, whether you turn it over to a collection agency or not. So it certainly can't hurt you.
You have comments on that?
No, I
Okay.
agree completely.
Another question is the annual posting of subsidy for low income a requirement for local municipalities, or is it just for districts?
Everybody's looking at me for the answer there. Okay.
Sorry about that, Eric.
No pressure.
I hate saying I don't know on that one. I get most of my experiences with water sewer districts, and in fact, until part of the presentation materials, that it was I was reminded that is a requirement. It would not surprise me that is a requirement. And when I have a moment here, I will look. I've got some statutes with me. I might find the answer to that here shortly, so I'll get back to you on that. But my guess is it probably is a requirement because it tells your other ratepayers that they are absorbing some of the cost associated with that kind of a program.
This is a matter of interest to all of you who are asking if you copy the slide. Yes, you will be getting a copy of the slide after the webinar. We get those posted online. We'll send you a link to that so you can have access to the slides. So, should a city follow the RCW in place, or could a city's resolution override an RCW?
A city's resolution can't override an RCW. So you would want to make sure that whatever your policy is, that it is not in conflict with a specific statutory provision. That's not to say that you might have a statute that says you can adopt a type of policy and then your policy would have more specific information. The guidance that we would offer is just make sure it doesn't contradict something that is authorized by statute, otherwise it could be challenged.
Okay, this is a little bit of a long question here, but if an agency has assessed every property connected to the water system at fee, and those funds are used to pay the outstanding bonds or loans for the construction water system, can you enforce your lien for more than 4 months delinquent payments?
You know, I'm guessing that question may relate more to a ULID assessment as opposed to a water or sewer or utility charge, and so I think that probably would be a separate category, and I believe that there's a separate statute that relates to the collection of ULID assessments. Statute of limitations, I want to say it's either 6 or 10 years on that. So that would be a different collection process. But importantly, if it's a ULID situation, it's already encumbering the property. So you'll likely be able to recover that through a lien foreclosure action.
It would be more, I think, lien foreclosure versus termination of service. You wouldn't terminate service.
We'll try to look that up and get a bit more information on that when we do the look at the questions in more detail later on. The next question is, what is your practice on fire hydrant water usage? I would presume that would mean that say a fire district or maybe a city is using a district hydrant or something like that. Is there a different charge for that?
You know, I think there's some differences between agencies on how they deal with that issue. In my experience, a lot of the districts don't charge a fire department, for example, for using water, where they're training, and simply just kind of a cost that is borne by the ratepayer. So that's kind of my experience anyway.
This is Cheryl, and what Skyway does is we do not charge for water used out of a hydrant for firefighting purposes or fire training purposes. We ask the local fire district to give us a report monthly on an estimate of the amount of water that they use, and then we calculate that as a non-revenue use of water. We calculate it into our overall water usage, but there's no charge. Now, having said that, if it's a contractor, there's a meter that they use to register water from the meter that they use for construction purposes, and then we bill them the standard billing rate, but not for firefighting purposes.
Yeah, maybe I misstated the question, but I know that there are most codes that I've looked at, municipal codes from the city's perspective anyway, they do include procedures for contractors and other people that might be using water out of a fire hydrant. There's generally an application for that. There's different costings factored into that. So if you need any policy samples on that, I can get them for you.
Hey, John, let me jump back to the question about the ability to adjust or delay rates for low-income persons. So the statute that relates to water sewer districts is 5708014 that has specific language in there requiring the notification of special rates be given to your customers. I'm looking at the other statute that generally relates to other types of agencies, which is 74.38.070, and I'm not seeing that requirement to provide notification to your customers, but there may be another city statute that I'm not aware of. but there's also a good point to bring up here that says that any reduction in rates granted to low-income citizens in one part of the service area need to be uniformly extended to all parts of the service area. So if you have a policy, it's got to be uniform as to all your customers. So but ultimately, my recommendation is that it may not, you may not have to publish a notice if you're a city, but please check with your city attorney on that.
Thank you, Eric. Next question is, since you're not required to bill a tenant if the account is in the owner's name, can you charge a fee on that bill for the courtesy billing to the tenant? Any thoughts on that?
You know, I would, you know, the districts, for example, have the statutory power to adopt regulations that govern, you know, they have the full authority and power to adopt resolutions relating to providing their service. So if there was an extra fee associated with that, I think you probably could pass that on to somebody who requested a duplicate billing.
I can say that Skyway has come full circle on that issue. Probably 20 plus years ago, there was a duplicate bill fee because there's time involved in the account setup. You know, there's postage, there's printing, there's paper. It's a cost of doing business. But it became a little bit cumbersome due to software capabilities at that time. So the district waived that fee because the whole, you know, the most important thing is to collect the bill. So, but just recently now, because the cost of postage has increased and printing and all of that, there is a fee now. And, you know, I do know that several cities that have a fee associated with that service just to recoup the cost of providing the service.
We have a number of other questions here. I think we'll probably take two more now, and then we'll respond to all the questions at some point when we at the end of sometime in the near future. One thing on that we had one person left a note on things, says WAC 480 110 355 gives disconnection instructions for medical emergencies. So you might make a note of that, and we'll make sure that information gets passed out when we send out the link. Let's see here. When does the clock start on the 4-month delinquency requirement before shut-off? From the original due date or from the beginning date of the service period? Any thoughts on that? Heidi, what the city of Issaquah do? What's their thought on that? When does the clock start on the delinquency requirement before the shut-off? From the original due date or from the beginning date of the service period?
Right. So the city of Issaquah bills in arrears, meaning the 2 months takes place and then you bill it. So ours would be at the start of the bill. So, for example, if you have a May, June bill out there, end of July, August bill out there, the May, June bill would be due in July, penalized in August, and then on the shut-off in September. So the 4 months would be those 4 particular months, but you know, they would have received a bill, a penalty notice, another bill, and then they would be in the shut-off mode, and it would be that 4 months time frame. But only the past 2 months would be the minimum required to keep service on.
There could be an issue there, too, with respect to your policy or code could say that a bill isn't delinquent for a certain amount of time, so make sure that you calculate in what your code says about when a bill becomes a delinquency to make sure you're in a safe area.
Okay, one more question here. Can you provide a list of agencies we can refer customers to for payment assistance? I know that Heidi, that you had mentioned that City of Issaquah has a list of agencies. Is that something that's generic to the whole state, or
You know,
is that?
yeah, there is a new one. King County has one that's called, it's like dialing 911, but instead you dial 211. It's called Get Connected, Get Answers, and they provide all types of services, and one of them is utility assistance. We do have Issaquah Community and Services and the Issaquah Food Bank, which are local, but you know, there's St. Vincent de Paul's and several other organizations that are tied to the 211 number, and there is brochures that you can request and business cards that you could keep in the office so that if a customer needed that information, you could give that to them.
I'm assuming that if they, do you have material like that for Issaquah that we could post on our website that might be available to other agencies?
Yeah, I do. I'll get those to you, John, and then you can post that.
Okay. Well, that's all the time. We're running out of time for questions. We will respond to all of these questions via email and post them on our website as well. So we're going to conclude here in just a few seconds here. Thank you for participating in today's webinar. Again, just a reminder that you receive a link to the published webinar so you can revisit some of the material presented and share it with your coworkers. Please contact me, John Carpita, or any of our presenters if you have any further questions or need any additional information. Thank you again all for participating today. We enjoy serving you. You guys want to sign off?
Thank you very much. My pleasure to participate.
Mine also. Thank you.
Thank you very much.
Just as a note, all the artwork that you see in the presentation is licensed to purchase. So thank you again, and be sure to email us, call us if you have any questions.